What's up, everybody? Here we go. Happy Friday. Happy Friday. Happy Friday on the live. Thanks for tuning in. Sorry, I'm a little bit late here. Just kind of getting everything going, everything situated here. Wanted to go over the habeas petition again because, when I went live yesterday, I hadn't taken the time to really absorb everything. I mean, it's 45 pages, and you know, sometimes you can kind of glance through it and get the gist of it and do the reporting on it. But other times, and all the time, really, it's good to really sit down with it and take a look. So hopefully everybody's seen the article that is now out. Let me put it here in the chat for you. I'll put it up here on the screen too. But there are 6 overall arguments in the habeas petition. And it was interesting. It was just kind of some reporting steps that go into this. I think one good example of how, I mean, sometimes even lawyers, like if they don't practice before the Second District Court of Appeal, they're not actually going to go know what's going on with this. Hey, Shante, thanks for saying hi. Thanks for tuning in. I'm glad you were able to make it. You're welcome. Thanks for checking out. Thanks for enjoying the work. I'm glad I'm able to do it, and I hope everybody's having a good holiday season. I know Christmas is coming up. There's Hanukkah. There's a lot of holidays. It's kind of just a family gathering time for people. And then I'm also aware that sometimes the holidays are kind of tough on people too, if you can't make it home or if you just don't have a good situation to go to. And hopefully everybody's kind of hanging in there and enjoying the end of the year and kind of getting ready for 2024 here. But we've got the article up on the screen, and it is let me adjust here so I'm lower. That looks good. I'm still working on professionalizing my YouTube experience for you guys, and that's one thing I'm getting serious about for this next year. Is I want to put together a Kickstarter. I've kind of heard Kickstarter's the way to go. Kind of has an entrepreneurial vibe, but I have so many options with what's going on, and just the momentum that I have, and I really feel like I'm making some grounds on YouTube, and I think the Jonathan Majors case, everything that's going on with that and the coverage and all the interest in that was a good reminder for me. I'm like, man, I should have figured out a way to get over to New York for the trial, because there's such a thirst for coverage of it, and the reporters who are covering it are doing a fine job, but it's just a different way of covering it. Like I could have covered it, frankly, just so much more detail than the way they covered it. But it's just a logistical thing of getting everything set up, of being in New York for like 10 days when you live in California. But ideally I'll be able to do some kind of Kickstarter fundraiser and really build out legal affairs and trials into a big operation, because especially with YouTube, there's huge potential to really professionalize the production and do videos. And one thing that I could use is I could just do like video talks of myself talking and kind of send the B-roll to somebody, and somebody else could put that together, and we could get kind of a faster video production time of the different cases that I have. But anyway, regarding Lanez's habeas petition, and there's a link in the article to the actual petition, and it's labeled a writ. It doesn't have the word petition on it, but that's what it is. As a petition, is they want the court to actually issue a writ, a habeas writ. And it's a procedural thing, obviously, a legal process that really any inmate can go through at any time. It depends on if there's newly discovered evidence. So somebody who's had their case adjudicated, which he hasn't, obviously, but somebody who's had their case adjudicated years after the fact could bring a habeas petition to the appellate court if they had newly found evidence. But to have one brought this early, I'm not sure if it's like unusual, but a lot of the habeas petitions that I see are brought like years after the fact. But I was saying earlier that sometimes lawyers who don't who don't practice certain areas of law, like they wouldn't necessarily know. But when I was talking to various people yesterday, somebody actually told me that they're like, oh, the petition was filed with the wrong court. It should have been filed with the trial court. And that's not actually true. It was filed with the right court. It could have been filed with the trial court. It was optional, I guess, but it's not like wrong that it was filed with the district court. And if anything, it's like a strategic thing, because when you read through the petition, it mentions several times that there's an opening brief coming, that they have they reference an opening brief, and an opening brief is they're referencing Lanez's actual appeal, which he's had a notice in since just a couple of days after the sentencing, or maybe just a day after the sentence, I think. But it says moreover, the issues raised herein support and are directly related to the issues within appellant's opening brief. So that's why yesterday the panel was so quick to look at this and say, okay, there's good cause to have this heard with the actual appeal. Because, I mean, what else are they going to do here? It says blatantly, like, I mean, it basically tells them that there's not enough information in the petition for them to decide the petition just by itself, that they need to wait for the opening brief. So they're doing that. And that one obvious consequence of that is we're not going to actually get a ruling on this for like a long time. I mean, it could be a few months at least. Whereas if he had just filed the petition separately and not tried to join it with the appeal, we would probably get a ruling on it pretty quick. Maybe I'm not kind of sure, but it wouldn't be a written opinion like we're going to get now, and that any appellant gets in their appellate case. You get like a multi-page opinion that kind of goes over the facts and sums up why the court is doing what it's doing, whereas petitions oftentimes don't have that. So the appellate specialist that I talked to yesterday was saying it's smart, like strategically, to file a habeas petition alongside the appeal, just because you've got all the better issues there. So it does look like this is going to be decided in like, well, not decided, but just this is a really fast appeal, guys. Like if right now the opening brief is due on December 26th, and I've always been skeptical of that because that's like the day after Christmas. But the way they filed this, maybe they will file it on the 26th, and then that would be not fully briefed yet, because the Attorney General's office will respond to this. They might respond to the habeas petition and the appellate petition all in one filing, but once they respond, Lanez's attorneys will have a chance to file a reply to that, and then it would go to oral argument, and then it would be ready for the court to decide. So this could be a really fast turnaround on an appeal. Like usually it would take longer than that. It doesn't mean that the court's going to act really fast. Like it could take the Attorney General's office a couple of months to file something. And then even if Lanez's attorneys turn around and file their reply to that just within a couple of weeks, it could take, it doesn't mean that the court's just going to immediately schedule oral argument. Oral argument might not happen for a while. But it took a while to, obviously just like actually read through here and be like, okay, so what are the arguments here? And the big one, the one that relates to Kwan's statement, is Senate Bill 97. And I see somebody, it's asking about, just the bodyguard. What's interesting with the bodyguard is that to this day, he still says that he doesn't know who fired the gun. And that kind of goes to the importance of, and why you would have cross-examination, and the importance of having live witnesses for the jury to like see in person to assess the credibility. Because I mean, do people believe that he doesn't know who fired the gun? He was standing right there. He saw this whole thing. He was actually like it physically involved in the whole thing. I mean, it really, what he was saying kind of matches Sean Kelly's testimony up until he just says, I didn't see who fired the gun. It's like, well, other people did. But it's like, is that a believable statement? And as a prosecutor, if you were cross-examining him after he testifies saying that, you might really want to explore that. Be like, because I mean, even if he didn't actually see the moment the gun was fired, you'd think after the shots were fired and there were the bullet fragments, and something had happened to Meghann. I mean, obviously, like, wouldn't you be able to tell from like the activity that was going on who had fired the gun? Like, I mean, come on. It's just it's not. It kind of defies belief, and the fact that it also kind of raises the question of like why wouldn't he be willing to just come right out and say that Kelsey fired the gun? And well, I don't know. And one thing I wanted to correct is on the last live, because I mean I cover a lot of other stuff, and this trial was a long time ago. The motion for new trial was like back in May, but I had said on the live that they had raised the issue of Quan not testifying in their motion for new trial, but they actually didn't. Like if you go back and read the motion for new trial, they don't bring up Quan not testifying or like not being allowed to testify as an argument, because obviously it wasn't that he wasn't allowed to testify. It's that prosecutors wanted time to prepare for him to testify, and doing that would have maybe delayed the trial until after the holiday. And to keep that jury there, they'd already been there for like 2 weeks and expecting the jury to like be able to come back like January 1st or something to continue the trial. There could have been a mistrial. So that actually, I think, would have benefited Lanez, but they agreed not to call Quan as a witness under that area. But the Senate bill that they're talking to in relation to his testimony, because his testimony isn't even exculpatory, but it supports the idea that something that it would have been useful to have if he'd actually testified that way. Although I think he probably would have gotten killed on cross, just depending on how he did. Because remember, it was definitely discussed that he was going to testify, because we have that email that Sean Hawley sent Lanez saying that she doesn't think blaming Kelsey is a viable strategy. But in the email, she says it depends on how Quan does under mock examination, and then also how Lanez does under cross. So obviously there was talk that he would have testified like before trial even happened, and then he did show up at the courthouse. I don't remember seeing him. I think I kind of vaguely remember somebody that, looking back, I'm like, oh, that must have been him. But it's been reported by Nancy at Rolling Stone and James at LA Times that he was there, and the whole sequence of events where he wanted to be called as a defense witness, but prosecution wanted time to prepare, so defense just didn't end up calling him. But the bill that they're citing here that's relevant to Quan's testimony is this law that passed. Here, let me bring up the story, because I actually got this stuff a little kind of neater, compact summary down here. Is something that changes the standards, so that it used to be you couldn't introduce new evidence if it could have been discovered before trial or before the close of trial. So the idea that Quan's statement like couldn't have been discovered before trial, it's like he was there in the hallway, like sitting to testify. They could have done it. But under Senate Bill 97, which was actually just signed in October, it changed the law to allow evidence so long as it is like you can allow evidence that could have been discovered during trial, so long as it's presented without substantial delay and more likely than not would have changed the outcome of the trial, which that's obviously questionable here. And I think the AG would argue, why that it was presented with substantial delay, because we didn't hear about this in the motion for new trial at all. They didn't even raise the argument. James says, "What's up? How's it going, James? Thanks for tuning in." So the main argument is obviously the Senate Bill 97, but they've got 5 other bills that they're looking at here. And the appellate specialist I talked to, who files these, maybe not all the time, but is pretty experienced in it, says that really that's their only like legitimate habeas argument, because that's the new evidence argument. He says it's a pretty creative stretch for them to argue that they just didn't know they didn't know about the evidence because they just never asked him how he was going to testify. And it's also kind of hard to believe. It's like, really, you were going to put him on the stand and you had no idea how he was going to testify. And they don't have an affidavit from George McDesian, the trial counsel, like saying that. So he was saying that he doesn't think that, this is the appellate specialist I talked to, who's quoted in the article, saying that he doesn't think that's really going to fly. with the court. But the other laws that they talked about in here, it's like 5 other arguments that they made. 620, 124. Yeah, 518. It was Assembly Bill 518. So it ended a requirement that a crime eligible for different punishments be punished under the law that provides for the longest possible term. So they make an argument. Their first argument, if you actually look at it, you're like, okay, if the court accepts that argument, which is maybe a stretch, he won't even get a lesser sentence. They're just saying that, one of his count that was applied concurrently, they're saying it should have been stayed too. Which, if you think about it, well, if the court goes back and does that, that's not going to lessen his time because count 2 was applied concurrently. So it'd still be 10 years. But sometimes when you go through the appellate decisions, you'll see stuff like that. It's like a really long published decision that remands a case for sentencing. And then you realize that the sentence actually isn't even going to be less. It's just legally that's what they wanted to make some kind of like basically technical change. But the petition also goes on to say that he deserves to be sentenced not for his assault with a firearm charge, but for one of the lesser gun charges, because he got 6 years for the gun charge. And then there was the 4-year enhancement. And then he got 2 years for negligent discharge of firearm and 2 years for possession of an unregistered, but it was all served at the same time and part of it stayed. So if they did go back and resentence him on, your only charge that's going to stick is negligent discharge of a firearm, the 2 years, obviously he would get less time. But like, dudes, the idea of that actually happening. And one thing with this petition is it took a while to like really read through and be like, okay, what are the arguments here? Let me go back to it. There's a ton of stuff in here that's just like examples of like how a law could work. There's one where they like start talking about a murder case, and it's not really like they're not really going over case law. Yeah, it says, it's such a disparity may simply indicate a different rate of offending. And it's like kind of an academic paper just about these legal issues and laws and stuff. And it's like, okay, how does this apply to the case? So in light of the first part, he would, to prevail, he would have to show with statistical or aggregate evidence that Black people who are accused of special circumstances murder are similarly situated to white people accused of murder, but not charged with a special circumstance. I mean, I'm reading through this. I'm like, wait a minute. Why Lanez is in charge with special circumstance murder? Like, I think, could we get back to the case here? Like, it's just, there's a ton of stuff in the brief that just kind of made it a chore to wade through. But, anyway, in addition to Senate Bill 97, which is the one that would kind of ease the requirement for Kwan's statement being something that like does something now, that although it's a big question of whether it would have made a difference in the case and whether it was not presented with substantial delay. I would expect that we hear more about that from the AG's office. But the other arguments are this one about how he should be sentenced for one of the gun charges instead of one of instead of the assault charge, the main one, which I'm like, I can't. And they don't even really make a good argument about why. They just say that he should. It's like, this isn't going to go anywhere. But Assembly Bill 124 is another one. And this is when a bill that it was passed in 2 years ago. So this was already in place when he was sentenced. And actually, this is what they were citing in the sentencing and arguing. Like, this is why Baez and Varhoma had the psychiatrist up there who talked to Lanez on the phone, and she told the judge she would be actually willing to drive to jail herself and pick Lanez up and take her to the rehab that she owns herself, and he could live there instead of going to jail. But that's what they were arguing is under this Assembly bill. It says that the court needs to impose the lowest prison term possible if a person has experienced psychological, physical, or childhood trauma. So that's why in the sentencing hearing, we so much about Lanez's mother dying when he was 11 and having post-traumatic stress disorder and being an alcoholic from that, because legally that was kind of on their side. If they could try to make an argument like that and persuade Hereford, Lanez would have gotten, instead of 10 years, he would have gotten I think he could have gotten 2 or 3 was the argument. But Hereford rejected that. I mean, we had this all argued out. And the idea that the appellate court is going to see a reason to go back and question the trial judge on it at all. It's no way. That's just a discretionary thing for the judge. Because it says judges can still sentence to a higher term if they believe aggravating circumstances outweigh mitigating circumstances, and Hereford said that was the case here. He said that he cited the post-conduct activity, the post-shooting activity from Lanez, which included the online harassment. It also included the release violations, that kind of thing. Sean Adams, thank you so much. Is it true that Kelsey once said that she didn't even know that Meghann was shot? Yeah, I think she did say that in her testimony, I'd have to go back, because you know what? This article does have the transcripts to her testimony linked at the very bottom. Because when she was on the stand, first of all, I can't believe she had to be on the stand for 2 days, because that was just a management thing by Judge Hereford, not being able to get a witness, because her total testimony time was only maybe 3 hours or something, maybe 4 hours, maybe not even that. But just the way Hereford was scheduling everything, and with the breaks, she had to testify part one day and then the next day. But she was she was freaking not having it, So she was just I think she did say that something oh, I didn't even see. But one thing the transcript does not get is the emotion and how she was actually saying that in court. It'd be so much better if they had recordings of this. I don't know why. I mean, why can't they? Why is it so bad for the courts to record this stuff, at least audio record it for their own measure? But it's hard to convey the tone that she was saying it. Why didn't anyone bring focus to Kwan's whereabouts in the situation from the jump? And I looking back, because so much has happened in the year since the trial, but the 2 weeks when I covered the trial, it was just so new to me, because I hadn't heard anything about it and I didn't really know who the people were. But I thought the missing driver and the fact that Lanez wasn't blaming his driver for the shooting and wasn't calling his driver as a witness was the biggest as a juror, they would be instructed, you're not supposed to consider that when you're deciding guilt. But I'm dude, come on, this makes him look totally bad. And one thing my article today gets into, and I've printed this report before, this was reported during the trial, but the actual DNA evidence is important to go over. What was the sample that they had? Because when you go over the details of it, here, I'll bring it up in the article. It says that most of the DNA sample that they got was so they get a sample of DNA from the gun. This is from the gun that was fired, that was actually still hot when the cops pulled the car over, and it was at Lanez's feet. And they swabbed it for DNA, and they go back and test the sample. And the sample says that one person contributed 90% of the DNA. So the criminologist who testified for the prosecution, who also testifies about half the time. Sometimes he testifies for the defense, but he was a prosecution witness this time. Randy Zabeda testified that was enough. Having that big of a DNA sample was enough for him to determine the gender of the person. So he concluded that whoever contributed 90% of that DNA sample was a man. And the cops had taken Lane's DNA sample. They didn't take anyone else's DNA. They didn't take Kelsey's DNA. And that's obviously controversial. They bring that up to this day. And that's brought up in the habeas filing that he was the only one swabbed. But when they took Lanez's DNA, the criminologist who determined that 90% of this sample was from a male was able to determine that male was not Lanez. Lanez did not contribute to the 90% of the DNA that's on there that has to be from a man. But then the 10% of DNA that is not part of that, that's not from another man, he said that there were 3 other discernible types of DNA. So it was 5%, 3%, and 2%. And he testified that those samples, that amount of DNA, was too small for him to determine gender of the contributors. And it wasn't enough for them to compare it with Lanez's DNA either. So that's why they were able to say he was excluded from the 90% sample on the gun, which was a male, but they couldn't say whether he was included or excluded from the 10%. So when we talk about the DNA, that kind of gets overlooked is all the details of that, because that was the testimony. It was a 90% male. And then the defense testified to pretty much the same thing, but they also argued that one of the smaller samples had to have been from a female, but the criminologist got up as a rebuttal witness and disputed that, said this is way too small of amount of DNA to tell one way or the other, like whether it's a woman or not. So I just remember at the time when I first heard this, I was like, okay, like if Quan did this, why? If he did this, I don't think Lanez would be willing to take the blame for him. And to me, it was just like very telling that most of the DNA on the gun is from a man. And that if Quan did this, like I said, even though they're homies, like would Lanez be willing to take the fall for him? I freaking doubt it. He'd be blaming Quan for it. So I don't know. I always thought that was just like a kind of thing. And it's one thing that's gone like not really reported very much. And it is this 90% sample. So if they had taken Kelsey's DNA, and granted, it's not like when the cops decided not to take Kelsey's DNA, they knew this was going to happen. They were probably just being kind of lazy or whatever. Why didn't they just do it? But the same thing would have happened though. Because I think we can all conclude, I don't know if the bloggers will be able to accept this, but we should be able to all agree that Kelsey is not a man. So she wouldn't have matched the 90%. And then the criminologist would have testified to the same thing that he testified to with Lanez, that the DNA sample for the other 3 is just too small of a DNA sample to tell anything. Like just how he said it was inconclusive, neither inconclusive or exclusive with exclusive with Lanez, he would have said the same thing with Harris. So it's this 90% thing has always been like, okay, I wonder whose DNA that was. I don't know. It's always been, kind of an interesting thing. Somebody asks if do you know if Tory is receiving letters and messages in prison? I bet he is. I'm sure they have him in some kind of restriction thing, but you can't. Who knows? But they can't just keep letters from people, And yeah, I hopefully they're giving that stuff to him. I don't know. I think the incarceration system in this country sucks. But thank you so much, D. Lazard. D, what is your opinion on Tory fans clinging to the idea that this will free him from prison? Part of it is kind of on the attorneys, because they want to represent their client, and I think the appeal is fine in doing this and putting this forward. But it's just that whole idea of false hope. Maybe it'll go somewhere. Maybe the AG will uncover some. I just no. But in the end, the fans are never going to go away. And one thing somebody once pointed out is that they really actually are more Meghann haters than Tory fans, and that seems true when you just see how vicious they are. Like, I can definitely not see them ever going away. So, but I think we're in for a few months wait on this. But if they do file that opening brief on December 26th, which I'm just like, dude, that would be crazy. The day after Christmas, they would file that. But maybe they will. We're going to get a ruling really fast. And then after that, well, not really fast, but sometime in 2024, the appellate court could decide this maybe. And that would be a pretty hugely fast turnaround. And then after that, it would really be be kind of over. I mean, there's stuff that you can do. You could try to go to the Supreme Court. You could do a habeas with SCOTUS too, eventually, if you wanted to. But it's just like there's just nothing really here. We can go back through the laws here, and here in a minute. I just kind of wanted to hang out with you guys in the chat, see if people had some good questions. Thanks for the supers and everything, and for the support, guys. But let's see the other law here. But yeah, that's one thing I noticed when going back to the story, was that I'm like, Hereford has already decided this, and they really give there's no like legal argument in here about why the appellate court would rule differently than him. And as the appellate specialist said, other than the stuff about Kwan's statement, most of this stuff shouldn't even be in a habeas petition. It's just like normal appeal stuff that they would argue. But I went over that DNA stuff, because that DNA stuff goes overlooked, and it's I bet if they had tested Kelsey's DNA, they would have found that. I'm like, no, they wouldn't have found anything, because like I said, with all the misinformation that's going on, we should be able to all agree that Kelsey's not a man, right? Can we agree that Kelsey's not a man? I mean, yeah. So, I mean, she wouldn't have matched the 90%. And it's the childhood trauma that's been argued. And this is Senate Bill 620. And this ended mandatory gun enhancement, giving judges discretion to dismiss. Lanez's petition acknowledges that the law doesn't allow him to seek formal relief, but he may invite the court to exercise such discretion in the interests of justice, and he's doing so now. This is another thing where the court is just going to be like, I mean, this was presented to Judge Hereford, and Judge Hereford had an option to do this. This law has been in place for 6 years. Like, he doesn't know about it, and he didn't do it. And the petition isn't going to be like, oh, well, childhood trauma, huh? Okay, force the court to do this. No, it's like that was all discretionary stuff that he already considered. And then this is the one, Assembly Bill 256. Passed in 2023, the bill changed the California Racial Justice Act to allow for post-sentencing proceedings to consider discrimination a defendant faced in his case based on race or national origin. And I had to look through the petition a little bit to be like, is that actually going on? It argues it applies to Lanez because of his Canadian citizenship. And I'm like, okay, somewhere in here it must also argue race too. But it's one of those things where when you actually read through it, it has tons of examples of race. Like, oh, here's an example of how the law works, even though I don't think that really even needs to be in a appellate decision or an appellate filing like that, like the appellate court being instructed like that. But their main focus is on the Canadian citizenship. They say that, and this actually got some attention when I put it on Blue Sky with some of the lawyers who are on Blue Sky, that new app. But it says that one of the reasons to deny him bail pending appeal was that he was an immigrant and facing possible immigration issues. It is such considerations which the RGA was enacted to prevent. It's like, okay, you're saying that he's been discriminated against because he's Canadian. I'm like, it's another thing where, and also they don't even apply it to the convictions or sentence. It's all something that happened afterward. But they also cite historical racism within LAPD. That's easy to do. And ask for an evidentiary hearing on the enhancement imposed by Judge Hereford. They really don't give any reason, like, why there should be an evidentiary hearing, and they completely leave out the fact that, like, I mean, Judge Hereford is Black. They're implying in here that Judge Hereford sentenced him to an enhancement out of racial animus, and I'm like, I'm not sure if that would that's actually going to fly, but what's the other? It's the other one here. And it's another thing, when you read through their argument on that, there's like paragraphs and paragraphs of stuff that's just like examples of how the law was applied in other cases that are not Lanez's case. It's like, okay, like, could we get back to the case here? But and it's not really cited in the same way as like traditionally just citing case law in briefs. But then there's this other one, Senate Bill 467. It expanded California's definition of false evidence to include repudiated forensics or scientific evidence. And this gets back into the DNA stuff, where it's like, okay, you guys agreed to this. And it's kind of an example of a plain telephone too, I think, through attorneys, an example of, attorneys doing this who weren't actually there in trial, because it's a real tortured argument to try to read. And the bottom line is they didn't object to this in trial, and they had an expert who actually testified to the same thing on it. And what always kind of galls me about the DNA argument is, in the end, the DNA evidence was overall favorable to Lanez. Like it's a good thing for him that prosecutors went up there and weren't saying that his DNA was on the gun. Granted, they emphasized that, they can't say that it wasn't on the gun either, but it's like, okay, but you can't say that it was. So overall, it was not like the most incriminating evidence for him. But their point is that they see something in the testing that should have made it so he should have been excluded from the sample more, from those three samples, the three ones that I had just gone over. Then they said that he should have been excluded. So again, it's an argument that's been made before in the trial courts, and that Judge Hereford rejected. And like the appellate specialist I talked to, it's not really something that you would see in a habeas petition. Like the Quan thing is because they're saying it's new evidence, but this other stuff is kind of just typical appellate issues. But more DNA stuff. And I would include people to like read that, like copy and paste that DNA stuff if you need to. But this is the appellate specialist I talked to. And yeah, there's no declaration from, he's talking about the argument about Smith, because that's the biggest argument in here. And he's saying, I mean, they don't even really have a declaration from trial counsel to confirm that he didn't know what Smith's testimony would be. So the idea that this is going to like sway the court or like get them anywhere is questionable. But it's definitely going to be a long process before we hear anything. Like I said, they're lumping it with the appeal. So the Attorney General's office is going to respond to everything at the same time, which could be a couple of months. And then they'll have a chance to reply, Lanez's attorneys will. And then there'll be oral argument. So it could be the summer before there's oral argument. And then after that, I mean, oral argument is a pretty good indicator. Like you can hear the justice's questions. Sometimes you can kind of get an idea of where they're going, but the written opinion comes after that. So again, I went again, there's 6 arguments, like six laws, 6 arguments. The big one is Quan's statement, which again, he doesn't say that he actually, he says he didn't see who shot her. And it's like, okay, first, is that believable? Like I said, the cross-examination on that, if he actually testified, it's like, really, you didn't see who fired the gun? You have no idea who fired the gun, like to this day. Like when you were in the car, you weren't like curious who fired the gun. You didn't like ask somebody, or like you couldn't tell from the way people were reacting. I mean, it's kind of hard to believe. But yeah, so like I said, kind of nothing for a little bit. Maybe December 26th, Boxing Day, well, I'll be looking at it. Well, actually, if they do file that brief on the 26th, I'm like, will I even be able to get it from the court? I'm not sure. I'll have to see. But I'm expecting maybe they ask for an extension on that, which of course they would get. Like Harvey Weinstein's lawyers have asked for like 3 extensions, and they get them no problem on their opening brief. But if they do file it on the 26th, we'll be, in for a pretty fast appellate turnaround over 2024, just compared to other cases. But again, let me go back to the article here. some good things going on the website. Said the Jonathan Majors trial is going on right now, as I'm sure you guys have seen. And the toxicity on that. I mean, it's one thing though that taught me. I'm like, man, I should have just gone over here and just covered this trial myself, because I don't think the coverage has been so spotty, and people don't get into all the details that I think they could. Yeah. Oh gosh. Sean Adams, is this your real name? That's one thing I've been meaning to do that I haven't done, is keep a running tab of all the fake names in the chat. It's kind of funny, but he's. And see, and the thing is, it's like I saw somebody on. First of all, some of his people bring up stuff that his lawyers don't even bring up. And one thing that's interesting to me is how kind of detached, and they weren't really paying attention to like the details of this until after he got sentenced. It really set in a frenzy. But during trial is when some of this stuff would have been useful. Some of this like analysis stuff that I've seen, because I've seen some stuff on my YouTube that's like, oh yeah, well, people are still wondering about. I'm like, dude, it doesn't, like, the point of the trial was not to like persuade or calm all the people in the internet chat rooms. It was the 12 jurors, and like I said, we haven't heard from them, but the tone of the trial was just so much more than that. And the whole idea, I've seen some people, and it just shows a lack of awareness of how the courts work. And if his lawyers aren't willing to bring it up, like, especially he had Ed Wellborn actually knows what he's doing. The whole idea of that Sean Kelly's testimony changed because people have brought up questions from the preliminary hearing, I think, that were asked about his statements to investigators, and then I think some questions during trial. But legally, it would never be considered that his testimony changed, because his testimony is him testifying in front of the jury and being able to be cross-examined on all things. So if he made statements to police before, like, this is your chance to like really expand it. And when I was sitting there listening to him testify, that was like the 20th or something, I was struck how I'm like, I don't think anyone's ever really talked to this guy like very thoroughly beyond just a few minutes of like, hey, what'd you see? Okay, that's great. Because I remember in the opening statements, George McDesian really presented Sean Kelly as like this bombshell defense witness that was going to get up there and say that he saw that he saw Kelsey with the gun. And I was like, okay, we'll see how this plays out. And he did say that in the beginning, but then he goes on to like clearly identify Lanez as the shooter. And you can kind of tell that it was the first time that Kelly had ever really talked about this before, outside like maybe one of his friends over a drink or something. Like the prosecutor's office too I don't think the prosecutors were really that worried about it, because in the end, the reason Sean Kelly called 911 is because he said he saw a woman being like beaten outside of his window. So they didn't think that he was actually going to be that defensive of a defense witness. But Sean Adams says, can we just agree that Tory's legal team was not good? On some counts, yeah, but I think Sean Hawley was good. I mean, what did Hawley do that was really so bad? The stuff about how she didn't prepare, or she didn't get any DNA reports until 2 months before trial. It's like, well, she still got them, didn't she? I mean, she, and just the emails, when you read her emails about the way she was dealing with Lanez, she seems like a good attorney for that case. And I don't really see where she made any missteps. I think McDesian, and I've talked about this before, especially when I sat down, I was like, oh my God, this guy's the lawyer. But I think it's a little unfair to like trash him as like this whole thing is his fault, because he just came in at not the last minute, because the emails do show that he had been involved in the case for a few months before that. like before with Sean Hawley, but he really took over in the final couple of weeks. And he has some criminal experience. I actually see him over at the federal courthouse sometimes, and he does mostly civil cases, like personal injury cases, and he does trials. Like he just sued City of Beverly Hills. He had some trial a while back. I don't think he won, but that's kind of common. He's won some stuff, but he was definitely a little rough around the edges. But some of his cross, like kind of funny, his best cross was probably the issue that they bring up in the appeal about the Instagram comment and the fact that somebody said, people saying Kelsey shot her on the Shade Room, and Lanez replied to it and said that's not true. And prosecutors presented as evidence, and really, like, the defense on it, like McDesian's point in his cross-examination was that this could have been somebody else who wrote it, that Lanez has a social media manager and this shouldn't be blamed on Lanez. And that's the point that's brought up in the papers. But I thought that came across like actually pretty well. It was just like such a minor point, you know? So I mean, the idea, I mean, maybe Lanez might actually shoulder a little blame here, and not just his lawyers for what happened and how this all went down afterward. And I would never say that Baez is a bad lawyer. I think if he'd had Baez for the jury trial, like it could have been, you know, because Baez is like just like kind of a professional bullshitter with juries, and he just knows how to do jury trials and is more experienced than McDesian. So maybe he would have had a better chance. But post conviction, I mean, it was kind of like, dude, how much money are you charging this guy? And Barhoma, I just think Barhoma is like, gosh, charging. I mean, how much was Barhoma charging? And he has no experience. So I would agree, post conviction, he had serious problems, but I would never say that Sean Hawley was a bad lawyer. I would feel a little bit bad just saying that McDesian is just a bad lawyer. I don't think that's true. I just think he was kind of in a different situation than he was used to, and just kind of came in at the last minute. But yeah, post conviction, he had problems. And his lawyers now, I don't want to say they're bad lawyers either, because I mean, I remember they've only been lawyers a couple years, and they have their law degrees online, but that's really no different than like somebody who just graduated from UCLA Law School and doesn't have any experience. I mean, they're about on the same page. And I think she has more experience than somebody like that. It's just like, in the end, sometimes there's just only so much your lawyers can do for you. I mean, like there's other cases I could bring up on that, but some other stuff going on here. I don't see, gosh, I wanted to bring up the Jonathan Major stuff. I was actually trying to find, it's like, and people don't know how to present this to the public. I'm like, where is a hub of just all the evidence that was released? Because I know there's like the call, and then there's the video, which here, I'll share it right here. This is the video. This is like right after. I think this is like right after it happened, because you can't see the actual assault. This is like the aftermath, the way she runs after him. But I'm like, yeah, well, it looks like they're all pissed off and fighting or something. But I mean, all the evidence is like, it's kind of all just stuff that surrounds there. But I'm like, it really annoys me that it is impossible to find this video without the big TMZ thing in the middle of it. It's like, God, why do people do that? Especially for stuff that is just, I mean, it's just public record evidence that was released by the court. It's just being in California and not being familiar with the Manhattan court system. I'm like, I can't just immediately get this myself. I need to contact the court and see. There must be a way for them to send this stuff digitally, you know, but this is kind of the big thing. But the one thing that just amazes me and makes me want to back away from this case is how toxic everything is online, and all the people who are saying, oh, I'm the best source for non-biased news, and then you go to their page and they're calling the alleged victim in this a hyena, and like putting gifs on of like a frog running to like make fun of her. It's like, no. this would get you fired from any news organization. Like, including, like, you can have an opinion about things. Like, opinion columnists have a tradition of course, you could go to a courtroom and like write your opinion about the evidence and how you think it's coming in. But this kind of derogatory comment and stuff, it's like, what the hell? Like, and it turned. One nice thing that I've seen is they're really not getting huge traction. I mean, they're getting some interaction, but it's very insular. It's like all these people just with themselves. Like, I mean, and there's just a real celebrity obsession vibe to the way people are just so obsessed with it. And, oh, come read our non-biased coverage of his false accuser. It's like, okay, that right there. Do you understand? It's like, what are there alternative facts? Like there's a way to be alternatively non-biased, And I don't know. It's really gross. And also how obsessed with it some people are, like just, I mean, part of it, I do think a lot of it is just genuine, but when you have an actor like that, a major Hollywood actor, he's got a lot to lose, just like reputationally, he was good. Marvel was planning, all this stuff. Like the idea that his PR people aren't part of some of this online stuff. I do think a lot of it is genuine, and a lot of people are just organically supporting them. They're not being paid by anything, but some of it has to also be swayed by that. But yeah, there's definitely a Depp Heard vibe to the whole thing. Kelsey says, I just read an article about the Depp fan base now supporting Majors. Not a surprise. Yeah, the Daily Beast article. I need to read that. But Sean Adams says, Sean Kelly didn't know there was a gun involved. He specifically said he never saw a gun. He thought it was fireworks. Well, yeah, but that he went over that on a stand. He said it was muzzle flashes. And then in the stand, like if you heard him on the stand, like he's like, he realizes what he saw. Now there was a shooting. Like the flashes that he saw were a shooting. So, I mean, that's just like why we have jury trials. But one thing I want to do, and just the interest this gets, is I can't believe it's been a year since the trial. Like a year ago today, I was in court listening to, I think it was Kelsey testifying. But when I read back on my threads on that, what I should do is actually like go back and read my threads aloud. Would you guys like that? I got to do that. But I could bring it up right here, but we could do like a reading where I just go through all the threads from the trial and remember it. I think that would work well. I could set it up for next week. We might have to do it over a couple of days because there's a lot of it. It'd be a lot to read out loud in one day. But when I go back and look at it, I'm like, man, this is great. And that's the thing, is it has the tone of the trial. The transcripts don't have the tone at all. Like, I mean, people were reading Kelsey's testimony literally and not realizing that her tone and how standoffish she was. We can go back through my tweets and kind of bring it up and read it. But that's a big thing. Witness demeanor. I mean, the jury's instructed that they can consider all of that when considering the credibility of witnesses. So, but yeah, I could go, here's the folder, and I shared this on the live last time, but I could go through all these. 16 pages, 11, 10, probably do it over like 2 or 3 days, but we could culminate with kind of reading the verdict at the 1 year anniversary of the time that it came in, that Jay-Z is a bitch tweet. But I can bring up the first one here. Trial opens today for rapper Tory Lanez. Will Kylie Jenner testify? Like, no, she's not going to. I always knew she wasn't going to testify. Alex Spiro, yeah. You don't get to see the interaction on the PDF, but I can bring that up kind of as an aside if I do that. Thanks, everybody, for the supers and for tuning in and everything. I'm trying to see if there's any updates on the Majors jury. Let me see. Because we've got the photos. The photos of her injuries, like her neck. We had those. We had the 911 call. We had the video of her like running and the running after him, and the spin on this is just, it's crazy. And I remarked on it in a video interview, and it's interesting. And I think it shows the coordinated effort on this, because I remarked on it in a video interview and I posted it on Facebook, but my comments are actually like a minute in, and most people do not watch videos that far in, but a lot of the replies are about a comment about, him scolding her in that phone call, which he totally is. And the people responding are, of course, men. And they're like, oh, this is just a way to talk to that girl. Of course, they call her a girl, which is kind of indicates their sexism right there. But one of them ended his comment with, you've obviously never been in a relationship or something. I'm like, this is so misogynistic, but it also just seems, I don't know. I like I said, I think a lot of that is organic and they're not being paid off. But some of it, when you have a major Hollywood star like this and a big PR team behind it, I'm like, a big part of this is internet stuff. But there needs to be an article written about these trial truthers who've arisen, though, and kind of just act like the public is just getting lied to about what's actually going on in these trials. So they're going to go to the trial and like tell you the truth about what's going on in this trial. And they're not like trained, like experienced journalists, and they're very detailed. And sometimes it kind of like they might be getting detailed information about this that you don't really see elsewhere, but they're completely one-sided. And the fear is that, I mean, they're the ones who are kind of like being totally biased about this and making it so that if the verdict goes a way that they haven't told people is going to happen, there's going to be a lot of people like who are just like, what the fuck? I don't understand this at all. But like I said, a lot of those people don't really even seem to be getting much interaction online. But it's because I get all these messages from people like kind of begging me to cover this because they want more straight coverage about what's going on. And one thing is just the way that people present this information. I'm like, why, if I had all these, and if I'm going to see if I can, I would have like a hub of like, here's all the evidence in the Jonathan Majors trial, and you can just scroll through and it's all the videos. Because there's the 911 call the night it happened. There's that call a couple months ago where he's like talking to her about how or not a call, but it's a recording that she made of him where he's telling her that she wants to be more like Coretta Scott King or using them of examples of women who properly support their men or something. But and one thing is the vitriol online. Somebody talked to oh gosh, sorry. got a few things going on here. No, he's not wasting his money. He can keep giving me supers. That's okay. Thank you, Sean. But no, I appreciate it. But anyway, back to the major stuff. I kind of just realized that, gosh, I should have gone over to this trial. And it's just a matter of making sure that it's actually worth it through like, frankly, monetization and stuff. And at this point, I'm not really sure it is. Just, I mean, the money for the hotel and everything, it's like, would you, through the, lives and things like that, or, but it maybe in a year or something, I can be in a place where I'm actually doing that. But especially trials like this, I'm like, man, we need like more straightforward coverage on this, because the way the trial, the rise of the trial truthers, I don't think is good for a lot of this stuff. And I mean, it's one thing that really bothers me too, is if they want to put their own spin on it, that's fine. I mean, we've had people doing that in journalism for forever and ever, but I really don't like the, like I said, the, comparing to the victim to a hyena and putting all these gifs on here that are just really unprofessional and things like that. But I really wish they would not just sneer and bash all those reporters who cover courts in Manhattan and are covering that trial. And some of these videos that I've seen, the people are sitting at their home. They're not actually covering the trial. I mean, like me here, but they're actually reading through all these reporters' work, like the work that they did, that they spent all day in a Manhattan courtroom listening to this, putting together an article, like it's not a job for them or something, you know, but these people are just putting this on the screen, sneering at it as they go through it. But this is their entire source of information. Like, this is how they're finding out about the trial, is these articles that, you know, the headline of the video is always just like, you know, here's what the media isn't telling you. And then you look at the video and it's actually just like them putting up mainstream media articles and like reading them out loud. It's like, go fuck yourself, dude. I really don't like that. One thing, you know, and I'm not, I mean, I do see room for my coverage on the Jonathan Majors stuff, but one thing I'm not going to do is trash the reporters who are covering it. The mainstream reporters who cover, you know, tons of stuff in Manhattan and have been covering the testimony on it. Like, one thing I heard is because the driver's testimony, and I said in a early interview that he was the driver's testimony was really crucial, but I heard there was a lot of like translation problems issues with that, like lost in translation, because I've done that before where I'm quoting a witness who's talking to a translator, and you've got to kind of remember that you're basically just quoting the translator. You're not even quoting the witness. I've heard a lot of people had thought there were translation issues with what happened, but he was saying from the tweets that I saw, he was saying that she was doing everything. It was all her, that kind of thing. So I'm like, well, I guess it just depends on how the jury goes on that. And I'm not really sure, but it was the prosecution's side that called him. So I'm like, gosh, would they really call somebody who said that? But kind of the thought was that the translation issues also contributed to the prosecutors not really being prepared. Like, they didn't quite know how he was going to testify. So not being there in the courtroom though, and just with the way the coverage goes, I frankly don't know. I couldn't tell you because I did not see that go down. And it was just kind of a reminder of, man, I wish I'd gone to that trial. There's so much interest in this. And I really see oh God, dude, we're talking about the Majors trial. The transcripts say otherwise. The story told, dude, as I said, the transcripts do not capture the tone of it at all. Like, people read that and they're like, look, Kelsey said no when they ask if she saw a gun. It's like, okay, were you there when never mind, dude. Anyway, like I said, I'm gonna arrange some stuff where I can go back over all my tweets. I think that would be good because my tweets really captured like the tone of what went on. But here's Jonathan Majors' 911 call. And you know what? I actually haven't listened to this yet because, like I said, it's kind of a pain in the ass to like try to shepherd all this stuff together. But here, we'll listen to it, and I'll check my phone to see if there's any updates on the jury.
No one, you need police, fire, medical.
Hey, how are you? Is it medical?
No,
suicide, I think.
What is the location?
252.
New York City, 911, you need police, fire, medical.
Hey, how are you? Is it medical?
No,
suicide, I think.
What is the location?
252 7th Avenue.
All right, so that was 252 7th Avenue, correct?
Yes, ma'am.
What apartment?
Penthouse D.
Penthouse D?
Yes.
As in David, right?
Yes,
this is in Manhattan or in Brooklyn?
This is.
Hello, sir?
Yes, ma'am. This is in Manhattan.
You're losing service. I'm sorry. Okay.
Okay, it's okay. It's in Manhattan.
All right. So this is Penthouse D. Just stay on the line, all right?
Okay, we'll do.
Penthouse D as in David. Don't worry about it. Speaking to me is not delaying anything. I just need some help, some information for the crew. They're already on the way, okay?
Okay.
Suicide. Let me get them going. What happened exactly? Do you know?
No, I don't know. But she's unconscious. She's naked from the bottom down. She has a sweatshirt on. She's my ex-partner. We broke up. I came back. She sent me text messages insinuating as much. I stayed in a hotel last night. I came home this morning. I banged on the door. I've been at the apartment for about 40 minutes now. I banged at the door. I couldn't get in. I finally went downstairs and asked the doorman to help us. And they let me in via the handyman.
All right.
Yeah. She's 30 years old. White, female.
All right. Does she suffer from anything prior to?
Um,
Or no, she have a
I would
mental
say she's
condition or
depressed.
history?
I would maybe say so.
Alright,
She has a history with,
what's her name?
her name is Grace, Caitlin Natasha Jabari.
Grace. All right. All right. Do you know what she did or what she took, or you don't know?
No, I don't know. I just know she's
All
unconscious on the
right.
floor.
No problem, sir.
Yeah.
And I'm going to get you over to the EMS. Do not hang up, all right? They're already en route, okay?
Okay.
All right. Stay on the line. Hold on. Arrow? 639. I'm 2880 for the job number 1749.
Hello, caller.
Hey, how are you?
Hi, this is 252 7th Avenue in Manhattan.
Yes, sir. Right over the Whole Foods.
And the patient's breathing?
Oh, yes, sir. She is.
Okay, is she awake?
No.
And phone number for you, 214-601-9547.
Yes, ma'am. Yes, sir.
This is Penthouse Diaz and David.
Yes, sir. Penthouse Diaz and David.
Okay, you're with her right now?
I've come downstairs to let the lineman know that you guys are on their way. So
they're going to be there as soon as possible.
Okay.
Obviously, if you could
What should I do? What should I do?
If you could just make sure the door's open, and when you get upstairs, she didn't fall and hit her head, anything that you know of, right?
No, I think I saw a cut behind her ear.
Okay.
Yeah.
How old is she?
She's 30 years old.
Okay. So if you could just, when you get back upstairs, we just want you to keep an eye on her breathing. If she wakes up, we don't want to give her anything to eat or drink. Like I said, they're already responding.
I think they just walked in.
The ambulance crew?
Okay. I think this is the ambulance crew.
Is it the fire department?
I called them on with a good, I got a girl.
I think that's PD.
Yeah.
That's the police there.
Hello, sir. That's the police?
I don't know what's going on. She's conscious, but she tried to. Yeah. Yeah. So will you just keep that confidential? Fella, this way.
So you're speaking to the cops?
Yeah, I'm assuming this is either our guys. I mean.
Is it the police?
Girlfriend. I just came back home. Girlfriend.
Probably. Let me see if they're at the location. Sorry.
I'm leaving. I just need to phone and say goodbye to her. There's no note. Just knowing what happened. Wait, this way? Yeah. I probably got into the park.
Yeah, they're at low. The sergeant is at the location.
Okay, and just to confirm again, 252 7th Avenue, Penthouse D, between 124th and 125th in Manhattan?
Yes.
Thank you.
All right, no problem.
So yeah. Oh, and this guy. There's just so many people, and they know everything about this case. It's freaking. It's kind of creepy, but apparently the jury recently had the answers to their questions, and they're back deliberating as of like 45 minutes ago. And the way it is, I mean, they don't have anything. There's so much focus on like before and after, but they don't actually have any footage of what actually happened. And with the lost in translation stuff from the driver, I mean, it kind of seems like this one is kind of destined to have a hung jury. I don't know if it would be today or if they would come back Monday, but who knows? I mean, who knows what's gonna happen? But it was kind of just watching all the coverage and kind of the desire for coverage. It was a big reminder that I need to get myself in a position to get over there for trials like that, because I think we can definitely build out this YouTube channel enough. And if I'm doing lives after the testimony and doing detailed articles on what the testimony was for my mailing list and making it like subscription only, we could totally start building something there. It's just kind of a matter of getting it off the ground. So yeah, the 6 jurors thing surprised me, but apparently that's how it is in Manhattan civil court, or not civil court, excuse me, criminal court for misdemeanors. Misdemeanor criminal court, it's only 6 jurors there. So So yeah. And this is one thing where it's like, no matter what, these guys just put, I mean, it's this weird kind of spin on it where it's like, it's freaking weird. And they're like, and these guys are the ones who are like, hey, look at all this non-biased coverage of the hyena false accuser. It's like, okay, that wasn't a non-biased thing to say, but okay. Like, I don't know. And it's just this crazy incessant spin on it. It's like, and I don't blame people for just wanting to back away from it. I mean, I have a hard time trusting it because I want to read from people who are actually in the courtroom, but when they're at the same time calling the accuser of just point blank saying she's a false accuser and comparing to her a hyena, I'm like, I feel like this person might be a little biased. It's just me, but and when you just look at the interaction that they're getting and the cries that I'm getting for coverage, people are fucking tired of that shit, dudes. They don't like it. Like, they want real straightforward coverage of what's actually going on. Like, but anyways, it's just kind of a waiting game. I mean, I'm not really sure what the time is for jury deliberations in Manhattan. Like, if it's just a hard cutoff at 5 p.m. Because I mean, it's 4:15 now in New York City. Are we going to see a verdict today? And at least some courts I've covered, if the jury really, 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 really wanted to, they could stay later that night, or God, they could even come in on the weekend. I've never seen that. I've never seen a jury come over the weekend, but it could happen. I'm just not sure what the situation is in Manhattan criminal court like that. Like, if they have hard policies where the jury has to leave at 5, or all the court employees have to leave at 6 or something. So I'm not sure, but it seems like if they just like 45 minutes ago were not instructed, but got the answers to the questions. It says, this is the courthouse news service who's there today. The judge is giving a detailed reading of Major's charges per the jury's request. To recap: third-degree assault with intent to cause physical injury, third-degree assault recklessly causing physical injury, second-degree aggravated harassment, second-degree harassment. The jury just reviewed the rest of the evidence they asked for, listed below. They left the courtroom again to continue deliberating. Majors walked out as well, hand in hand with Meghann Good. Now we wait. And this is Josh from yesterday. First note was at 4:20 p.m. Verdict watching. Excuse me. They asked for a detailed judge explanation of each charge, showing interaction on Canal and Lafayette Street outside of Carr, which we watched. That's the thing that I cannot find without the huge TMZ right in the middle of it. It's so annoying. 911 call, full exhibit, which we just listened to. So, and I don't know. You can never like read the tea leaves on questions like that, but I'm like, man, if I was the prosecutors, that would make me nervous, because I'm like, shouldn't the prosecutors have made that clear in their closing what the actual charges were? It's no, but it sometimes maybe there's just one juror that they're trying to sway or something. It's always hard to like read into those questions about what's actually going on in the jury room. But I don't know, just the fact that they're kind of asking stuff like that can't make the prosecutors like too stoked. But who knows? They could come back with a verdict, right now, or who knows? I kind of think that they won't. And if they do hang today, there's a possibility that the judge would tell him that he can't accept like a mistrial yet, that they would need to come back on Monday either. So I'm kind of leaning toward, we're not going to get a verdict today. They're going to come back on Monday. But here, let me pull this back to my website. I hope you guys are checking it out. I've got some good stuff on there. I've got the Diddy lawsuit, which, by the way, I'm assuming Diddy's lawyers are going to file a opposition to the request that the plaintiff be allowed to proceed anonymously. So once that happens, I was going to do an article and send it out to the mailing list. But yeah, I'm not really seeing any jury updates from them. So, I'm kind of leaning toward, like I said, just like 5 minutes ago, I'm just going to keep repeating myself, but that there's not a verdict today. If there is, a reporter who's been covering it was saying she might be willing to go on a live with me, but right now I'm kind of I don't really have that set up in place. So if it does happen today, I don't think I don't think I'll do that. But if it's Monday, I might be able to get that set up. So oh yeah, and who's just been, and Andy's not part of the criminal case. It's just Caesar, but his lawyer kind of dropped off planet Earth in responding to my emails, and I even sent him a LinkedIn. But I'm gonna need. Don't call him next week because it's Christmas. But call him the beginning of the year, Massimo D'Angelo, and because I wanted to do that live, he was saying that he would, but now he's just kind of gone off the radar, and it's probably because Envy told him not to. But we haven't seen an indictment against Caesar yet, and Envy has not been charged. So there's still some civil lawsuits going on, but nothing to report yet. But we definitely haven't heard like the last of that, and that would be a good thing to kind of get prepared for. One thing, Boozy, a little Boozy badass, he's got a gun case down in San Diego that I was actually getting ready to go down there today because he had a hearing, some kind of motion to compel discovery from his defense lawyer, who I know, who's done a lot of cases that I've covered. But it says the reason they delayed it is it's not happening today is because there's a plea offer that the defense is reviewing. So that could be a story soon. Yeah, a little Boozy. He's charged with some kind of gun possession thing. He was like down there for a concert, and the cops saw an Instagram live he did where he's like packing a gun, and he ended up getting indicted. He's charged with felon in possession of a firearm in San Diego federal court. So he was supposed to have a hearing today, but it got canceled at the last minute. But that's definitely on my radar. And then the Lizzo lawsuit too. I know there's some litigation going on with that. I wanted to kind of get on that and write about that. And there's some other stuff, but it's Christmas. Everybody should kind of get ready and celebrate the holidays and be with their family and everything. So maybe everybody can do that. So I don't see any immediate updates on the Jonathan Majors stuff, but let me see here. Yeah, just kind of wait around, One thing that could be happening here, I'll pull this up, is here. The you guys might have heard about the defamation lawsuit against Rudy Giuliani on behalf of the Georgia election workers, and Kyle Cheney at Politico's in the courtroom, and he just got the final damages decision. Damn, 75 million. Whoa, 75 million punitive. Dude, this is huge. Holy shit. So 33 million for defamation. No, so it's 150 million total. 75 million in punitive, and then it's like 34 or 30. Yeah, defamation is almost like 35 million. Wow. 40 million for emotional distress. That's big. They really sent a message with that. Dude, the J6ers are freaking crazy. I'm telling you, man. They're nuts. And it's Christmas. It's Christmas season. No, that's what they were awarded. The jury just came back. Why did Caesar need to get approval to travel to NY? Because his release conditions on his current charges restricted him to the District of New Jersey, and New York isn't in the District of New Jersey, but it got approved pretty fast. But yeah, that's what was here. I'll tweet out from my phone, but wow. Rudy Giuliani has been ordered to pay about $148 million. That's crazy. But yeah, Rudy Giuliani's crazy, and I'm going to have to deal with this tomorrow because I live in San Clemente in California, and there are some crazy people around here. I mean, they had like 2 huge Trump rallies here during 2020, and one of the craziest J6ers used to live around here too. He doesn't live around here anymore, but he's got a ton of supporters around here, and these people are freaking nuts, guys. Like, I mean, all this stuff, all this election stuff. I mean, first of all, just keep in mind these are people who wanted Trump to be president, and then the stuff that they did, like driving to DC with like a car full of weapons. They're like storming the Capitol. There were people who died at that thing. And the people who were like currently defending him and like, I mean, he's running for president again. It's like, you gotta be kidding me. But yeah, that's kind of the big legal news right now. Here, let me get off screen here and see if I can find some majors update. Okay, but yeah, I don't see any Jonathan Majors updates either, but let me see. Yeah, nothing really going on. Again, the jury hasn't actually left yet. I haven't heard that. Again, the idea, it's not like, tonight they're going to get a check from Rudy Giuliani for all this money, but no, I wouldn't. No, I'm not gonna not. No, that needs to be talked about because it's crazy what's going on. Those J6ers. We'll talk about it right here, but yeah, I mean anybody care about this? I mean, what is Trump gonna say about this? Yeah. But I don't see any kind of update on Majors at all. I don't think the jury's actually left yet, but I don't know. If within the next like half an hour they do come back with a verdict, that would be pretty big news. But I could definitely go back on live because, like I said, hopefully one of the reporters who actually covered it can join me. But I've just been a little turned off at all the social media, just vitriol over it and everything, and I don't know, it's gross. But we'll see. Like I said, the thing is, there's just so much focus on all this, evidence, and it's none of it is about the actual, like what actually happened. The biggest thing is you see, the aftermath, him putting her back in the car, sure coming back out and chasing after him. Then there's also that surveillance video, which I guess has been out for a while, of her talking to the people out on the street. And the way it's presented is somebody will be like, oh, and you can see her tie up her hair and she doesn't have a finger injury at all. It's like, okay, that's like your interpretation of that. But when you see her talking to them, I mean, she seems distressed and upset about something. I mean, there's just like all these different ways to interpret the evidence, and I think that kind of shows why this could very easily be like just a hung jury, but we'll see. Maybe it's I wonder if it's considered easier or harder with 6 jurors. I've seen 6 jurors on a civil case, but not a criminal case. But anyway, I'm not really sure I've got much else to add. I don't see any kind of Jonathan Majors update or anything, but again, you guys can check out my article. Hopefully you do. Give me some love on the subscriptions and the YouTube likes and subscribes. And yeah. Oh, my notifications are going crazy. I don't even read a lot of them, honestly, because it's too much to manage, and all the news alerts are coming in on this verdict right now. But it's better just to stay in the normal feed. Anyway. I think that's it, guys. If anybody has any questions, but I think we kind of covered everything. I really love you guys tuning in. Thanks for the supers and everything. And I'm going to do something next week. Like I said, I think I should go over my Twitter threads from the trial, and we could do like a 1-year anniversary thing or something. So thanks so much, Daniela. Thank you so much for tuning in. I'll see you guys later. Happy holidays for sure.